Mr. Justice Craig Jones and Mr. Justice Lauren Rudolph presiding. My lords, the case before the court today is Jaya Kanthasamy as the appellant and the Minister of Citizenship and Immigration as the respondent. Good.
Your Lordship, good afternoon. May it please the court, my name is Biboli, first initial B, and this is my co-counsel, Mirka Berry, first initial A. We're counsel today for Jaya Kanthasamy.
Wong R, co-counsel Mortazavi S. We represent the respondent and Minister of Citizenship and Immigration.
Your Lordship, we are here today to ask the court to grant permanent residency to Mr. Kanthasamy on humanitarian and compassionate grounds based on three reasons. First, a correctness standard should be applied in the case at bar. Applying correctness is consistent with immigration law. Second, the plain meaning and legislative history of humanitarian and compassionate grounds requires a broad interpretative approach. This has been consistent with the court's treatment of discretion in the past. Lastly, to the extent this court adopts a reasonable standard, the decision to deport should be reviewed as unreasonable. Mr. Kanthasamy has lived in Canada since arriving as a teenager from Sri Lanka. During this time, he attended high school and worked part-time for his uncle. He has developed a close relationship to his uncle's family as well as made several close friends. Mr. Kanthasamy is a young Tamil born in northern Sri Lanka. The discriminatory treatment of young Tamils in Sri Lanka has been well documented over several decades. At the age of 16, he was detained twice by the Sri Lankan officials who suspected him of supporting the Liberation Tigers of Tamil Eelam due to his profile as a young northern Tamil male. He was only released the second time upon bribing the officials and was subsequently warned to stay in Colombo. He had also been pressured by the Tamil militant groups aligned with the SLA, further exasperating his precarious position. He then left Sri Lanka to join his uncle in Canada to escape prosecution and coercion into taking a militant stance. Moving to my first point, this court should adopt the correctness standard given the general importance. Applying a standard of correctness is consistent with the laws arising in the immigration context, and in particular with the scope of equitable discretion as per Baker and Chiu. The principal issue at hand is what the statutory term humanitarian and compassionate means. In Chiu, the court has held that the scope of this discretionary jurisdiction itself is a legal issue ultimately to be supervised by the courts. The humanitarian and compassionate grounds are rooted in Canadian values of significant importance, including family integrity, the best interests of the children, and the protection of the vulnerable. Canada recognizes these values as being of universal application. The discretion focuses on how we treat strangers in our country. The importance of the issue is felt by individuals and their families. The analysis requires a resolution of an issue, which an individual's rights are at stake, which are in many instances significant human rights. While officers may hold some factual expertise on humanitarian and compassionate applications, they lack expertise on questions of law. There is no oral hearing or little opportunity to acquire a real understanding of the individuals whose future in Canada they decide. They are civil servants, not lawyers. They are not judicial and quasi-judicial tribunals. There is no reason to create a judicial construct of legal expertise on the part of the immigration officers and border guards in understanding the complexities of the statutory discretion that they exercise. Officers are guided by instruction from officials, thus make no decision without direction.
Sorry, can I just stop right there? You're arguing in favor of a correctness standard to be applied here in these circumstances, but you're talking a lot about discretion and how much discretion is provided by the statute. I mean, if the court is just going to impose a correctness standard, then what is the purpose of having the legislation give any discretion whatsoever to the minister or his delegates to make this kind of assessment?
Well, the delegates, the officials, they get the authority to make rules. They don't make the rules or define, for example, in this case, the concepts of kindness and compassion.
So the court basically is just going to make these decisions in every case if you're going to apply a correctness standard. And so why not cut out the middleman and just have it go to court directly? And why is there legislation providing for this discretion to other non-court persons?
The reason in this case is because there's these various decision makers who have humanitarian and compassionate discretion, but in different contexts.
Okay.
For example, under Section 25 of IRPA, they're able to interpret it in one way, and under Section 28 2C of IRPA, as well as for CHRWA, the humanitarian and compassionate factors are considered to interpret this term in a different way. Meanwhile, this creates this inconsistency, and in Rogers Communications, it was held that inconsistency favors the correctness standard.
But you were saying that there's basically this fairly broad discretion that is provided to these decision makers, and there's a question of law at stake. I mean, didn't Baker and Dunsmuir specifically really point us to adopt a reasonableness perspective on these types of questions? I mean, you're saying they have no expertise in the circumstances. How could an immigration official have no expertise? I mean, I'm a judge sitting here, and I can tell you right now, I have much less expertise, I'm sure, than somebody who deals with these types of cases on a regular basis and has developed that field sensitivity to these types of cases. How can you make the claim that there really isn't expertise?
Well, if we're to adopt the reasonable standard, it does not really provide predictability in terms of human rights protection. Canada is seen as a global player, and we're part of the Universal Declaration as a signatory. And we need to ensure that we're committed to these human rights protection, and we need consistency in those human rights protections.
Thank you.
So can I follow up, Ms. Babioli, if a correctness standard were applied, it would fix, presuming that there is a correct decision in every case applying the language of the statute, it would dictate the number of refugees accepted. Whereas, I mean, as it stands now, if one person doesn't get refugee approval, another person will, because they have a certain number, I suppose, that they can let in every year. But doesn't applying a correctness standard essentially remove from the executive branch the control over the inflow of refugees? Because you would have to accept everyone that fits within the definition of, compassion, whatever we're interpreting here. So I guess my question is, isn't a reasonableness standard necessary in order to give the government sufficient flexibility to set inflow of refugees?
I believe not in this setting, given that it's human rights protection, but I could read the memo on that for further analysis.
So you think, though, that the statute, as it's worded, would mandate that the government accept everyone who correctly falls within the definition?
Within the definition of human rights protection?
Yes.
Yes, if they're being discriminated, it's not just a domestic issue, it's an international issue, and if Canada is is a global player.
Does the statute mandate, does it use mandatory language? Does it say that once the threshold is met, someone must be given refugee status, or once the threshold is met, they may be given refugee status?
I'm not so sure. I could brief you on that later.
Maybe when your friend is speaking, you could see if you could look that up and have an answer before you're finished. Thanks.
Good.
Thank you. Sorry to derail you. Carry on.
Co-counsel is now going to move to the second point.
Just to my co-counsel's point, I think the discretion granted is to make an exception to people who don't fall into other categories. So it gives that discretion to people, to the agency, to decide for some other grounds. The individual can stay in Canada as a refugee or as an immigrant. So it wouldn't really change the numbers game of who's allowed and who's not, but it would just affect the rights of the people already here and give them just one more kind of route to entering Canada or being able to stay in Canada. Now, why we're arguing the correctness standard versus the reasonable standard is because it's not that they shouldn't have discretion, but it's to what is the threshold for that discretion. So if you feel as there's real compassionate grounds there, how much compassion is needed? I know it's a hard way to quantify that, but it's to what extent is that to be met? Is it to be stringent limit to allow the people to come in, or is it to be a more, not lax, but more allowable limit to meet our human rights things with treaties with the rest of the international community?
So, sorry if I might, you are saying that you're suggesting that the court would apply correctness standard to the interpretation of the legislation. So there's only one interpretation, but then whether or not that is actually invoked in a particular case would still be preserved for the minister to make that
Absolutely, because discretion, there's no set limit on what those grounds are, so it doesn't define what compassion is or what humanitarian grounds are. But when you are applying that, you should read it in a more broad way than a more narrow way to, again, meet with our obligations internationally. And that is, I will start my second point with that. That will be kind of my segue to that. As far as the scope of our humanitarian and compassionate discretion. We'll start with that. The ordinary meaning of a term may not be determinative, but it has relative consideration. So in Rizzo v. Rizzo, it was stated that there's only one principle or approach, namely that the words of the act are to be read in their entirety and their entire context, in their grammatical and ordinary sense harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. So the Court of Appeal's reason in respect of the humanitarian compassionate discretion do not accord with the principles of statutory interpretation. Rather, it appears to have adopted a narrow interpretation. In the federal court has been applying the narrower test, and because in the court's view, it reflected the exceptional nature of the discretion, limited to very significant hardship. Individual humanitarian compassion factors should not be considered in isolation in the determination of the hardship that an applicant would face. Rather, hardship is determined as a result of a global assessment of considerations put forth by the applicant. Ministerial guidelines have referenced in court as guidelines for officers to consider, as per Baker. The guidelines cannot be considered law to replace statutory provisions through judicial interpretation. To the extent that the Court of Appeal did this, it is an error in fettering the discretion of the officers who are required to consider humanitarian compassionate factors, not solely unusual, undeserved, or disproportionate hardship. Secondly, we'll look at legislative and historical consideration. This court has noted in Hardale that the issuance of the minister's permits introduced an element of flexibility and humanitarianism into the administration of immigration law. It is submitted that humanitarian compassionate discretions remain broad in the current legislation, and the humanitarian compassionate terms have not changed since the introduction in 1977. The broad approach is not only consistent with the ordinary meaning of humanitarian and compassionate, as analyzed in Sherwa, it is consistent with this court's treatment of discretion in the past. Moreover, the best interest of the child was considered as essential humanitarian and compassionate value in Baker. In Chu, the court has held that discretionary powers given under immigration legislation, which are intended to provide equitable relief, the court has been consistent in concluding that they are unrestricted and to be broadly applied. So the narrow approach is not consistent with statutory objectives. Canada's immigration objectives reflect humanitarian values, including the protection of human rights, such as protection from harm and family integrity. These values permeate Canada's judicial system. Parliament left the discretion to be considered in all cases of foreign nationals who file a humanitarian compassionate application while in Canada, including those without status and those who make refugee claims. It's not the role of the court to interpret legislation in a discriminatory fashion. This is contrary to the objectives of equality and fair treatment, particularly where status is not an indicator of other factors, such as the strength of the person's establishment, ties to Canada, and the need for safe haven, according to Lau, Pushpathan, and Duong. As far as personalized hardship, part of the application was they felt that they personalized what hardship was needed to the individual as in the case of our client here. In debate, it was held that it was incorrect and unreasonable to demand an applicant establish that the circumstances he or she will face are not generally faced by others in their country of origin when conducting a humanitarian compassion analysis. In Abu Bakr, it was stated that there exist circumstances where country conditions are such that they support a reasoned inference as to the challenges a particular applicant would face on return. This is sufficient for applicant to establish hardship without having to establish that it was individualized or personalized. As in the case here, the individual is a northern Tamil of northern Sri Lankan descent, and he has had these experiences in the past. So it's not too much of an inference to see that it would be personalized to him or people of his class. The evidence indicates that Tamils face harassment and discrimination in the militarized and occupied north, with registration again required for northern Tamils in the south, and in the face of past history of violent persecution and discrimination against Tamils, particularly young male Tamils from the north. This point was missed entirely. The suspicion of the Tamil Tiger link is rooted in the profile. Young male northern Tamils are suspected as a class of supporting the LTTE. Discrimination arises based on adherence to the group profile. Finally, we will argue that the decision is not reasonable. In Chin, the court held that the principles of statutory interpretation have demonstrated that a review under a reasonable analysis is unreasonable.
Sorry, wait, just pausing there for a second. So this argument is in the alternative to us not finding that there should be a correctness standard to be applied in this case. So if we were to apply a reasonableness standard, now
Absolutely.
we're seeing that.
Absolutely. So the correct standard is not to be held by the court. We will further argue that the decision itself is not reasonable.
Okay.
In Chin, the court held that the principles of statutory interpretation have demonstrated that a review under reasonable analysis is unreasonable to the extent this court is not satisfied with the correctness standard. The reasonable standards should be applied and found unreasonable due to the discussion of the statutory interpretation. As seen in Dunsmuir, tribunals are recognized as having a margin of appreciation within a range of acceptable and rational solutions. Mr. Kanthasamy provided evidence regarding the harassment and discrimination faced. However, the officer erred in concluding that the applicant would not personally face discrimination if returned to Sri Lanka, when it is clear from his profile that he comes within a class that faces mistreatment. Ultimately, the conclusion by the officer is perverse in the light of the evidence before the officer. As far as the security measures, while the officer acknowledges some Tamils were singled out by Sri Lankan government due to the LTTE link, the security measures was simply to preserve the security of the Sri Lankan nation. However, we asked the court to note that the federal court has on multiple occasions held the security measures, which are discriminatory, arbitrary arrests are unjustifiable, especially when detention involves torture. Consequently, it is patently perverse for a Canadian official to justify egregious human rights violations of another state under the guise of protection of national security.
Can I ask a question, Lee?
Absolutely.
I take it that your discrimination, that the peril that he's put in, you're arguing is as a result of his profile as a young male northern Tamil. If we were to find that that was sufficient to make it unreasonable to not extend refugee status, then aren't we de facto deciding that every young male northern Tamil must be admitted to Canada?
That would be a grounds to admit people of that descent into Canada, but the question at bar is an individual who's already come here on that grounds and he's applying under compassionate and humanitarian grounds. So it's more of a justification of someone who's already immigrated here and a justification to not allow him to go back. There's also individualized factors involved here, considering he's been detained twice and that he has been he's only been released on bribing the official and then he had to leave the country. So there is a mixture of policy here as well as individual factors.
So you're not saying that it's unreasonable per se for this compassionate exception not to be extended to any northern male Tamil. You're saying that there has to be something more, individualizing it?
No, not necessarily. Canada does extend that kind of privilege to many different kind of discriminated against populations. I know personally in Iran, if you're from a certain faith, you are allowed that because you're persecuted on behalf of their faith. So it is, discriminating against a certain minority in a country has been well observed in the past to be grounds to allow people to emigrate.
I can see it being a factor, but are you suggesting that if you were Baha'i, for instance, from Iran, that you would automatically be awarded this compassionate exception?
Not necessarily, but you would have to look at the totality of the circumstances as well.
But there would still be a discretion not to. I guess that's my...
There would be, but it wouldn't be the fact that the officer here pointed out that individuality was the standard to meet versus something broader, which would be a broader form of persecution or discrimination here. So I can say I'm the one being persecuted for my personal beliefs, wherein if you can't prove that, but the risk of that exists, it would just be further grounds to apply compassionate or humanitarian grounds more broadly. So it would just be kind of extending an extra amount of discretion to the officer to allow him, because the argument here is that as narrowly defined now, it doesn't allow for much discretion. It's very narrowly defined to individualize persecution, which may be hard to prove or which may not really reflect how much risk an individual is at in a given country because of their background.
Thank you.
You have 1 minute.
We will just in summary, I will just say that there are other reasons as well, which in the reasoning for the officer of denying his application were security measures as well as psychologist reports. The officer saw that other factors may have caused his post-traumatic stress disorder. That was not the position of an officer to judge that. A psychologist is a certified individual who's been trained to identify these things, and it's not in the place of an immigration officer to question that finding. As well as the best interest of the child, the officer also inferred that he might be best to return to his family in Canada, or the individual is an artistic individual who's made roots here, who's graduated from high school here. So in summary, we put forward that the standards by which our client's application was denied on were unreasonable. They should use a different standard, as well as they were even if the reasonable standard was to be applied, the finding was unreasonable.
Lords, we're not talking about the improperly narrowing the test that my friends have suggested. Here, what we're talking about is an individual, in fact, in the law, trying to qualify for relief under humanitarian compassionate grounds after all other avenues for refugee status have failed. This is an attempt to be granted an exemption from demonstrating that he would suffer unusual and undeserved or disproportionate hardship.
Sorry, is that the standard for refugee status?
This is under Section 25 of the test to be exempt from qualifying the other way through the immigration.
So you're saying this is a person that doesn't qualify under that standard, and so this is a further last hope clause.
Exactly. And in this case, the appellant failed to demonstrate that these are requirements in compliance with the Act and the law. So considering the facts before the humanitarian compassionate officer, in this case, she assessed the information holistically in accordance with the current law, and in doing so, her decision to refuse the application should be assessed on a reasonableness standard and was in fact reasonable for 2 reasons. The first being that the differential standard of review provides for substantive leeway to determine the proper purposes and relevant considerations involved in making this particular decision for this particular case. And as my colleague will address, given the deference owed in this case, the officer's reasons were also justified, intelligible, and transparent, and the decision itself fell within the range of possible acceptable outcomes, which are defensible in respect of the facts and laws under these circumstances. Considering these points, the and the applications of the facts to the law, the agency officer's reasonable exercise of discretion should not be disturbed.
Can I ask that just with respect to the statutory history here, this provision, this faint hope clause, whatever you want to call it, was it part of the statute from the beginning, or was it added at some point? And can you tell me anything about the reasons for its adoption?
This was added through Bill C-11. The reasons for it was to be a flexible approach for immigration officers and the minister to be able to admit applicants if they meet the test for undeserved, unusual, and disproportionate hardship, if they were to return back to their home countries.
And was there any, I mean, it seems odd that the exception almost seems more broadly defined than the term it's an exception from, you know?
Yeah.
Was there any controversy at the time that was there a particular class of cases that people were concerned wasn't being captured or wasn't being addressed, and so they needed this? Do you know anything about it?
From my understanding, the issues were unanticipated or unforeseen consequences of not being allowed in, for whatever reasons they would have been, that this exception was put into the legislation so that the minister or the officer has the discretion to exempt the typical avenue of immigration to stay in the country, or else send them back if they don't meet the law and requirements.
Thank you.
So my first point regarding the deferential standard, here the Supreme Court in Baker recognized that considerable deference should be accorded to immigration officers, as in this case, considering humanitarian compassionate relief. Given the fact-specific nature of the inquiry, the role within the statutory regime as an exception, as I just mentioned, the fact that the decision maker is the minister, that the discretion of the minister is inherent in the legislation, as it's his opinion whether or not the risk is undeserved, disproportionate, or unusual. And the expertise, as previously mentioned by the bench, that the immigration officer and the minister are interpreting their own statute and experts in this field.
So would you describe this then as a question of law? Would you agree? This is a question of law, or is it a mixed question of fact?
This would be a mixed question of fact and law. The law itself is what it is, and interpreting it a certain way is a question of law, but the application of the facts to this particular case, to the decision of not allowing the exemption to apply to this applicant, is a question of mixed fact and law. And therefore it should be assessed on a reasonableness standard.
So you're arguing in favor of basically maximum deference here being provided by the court to assessments made by the minister or these immigration officials who are delegated down the power from the minister. But, I mean, what about concerns about consistency, human rights? I mean, are you going to address these points that your opposing counsel has raised?
The concerns of consistency are addressed by the application of the guidelines within set out by the minister for humanitarian and compassionate grounds, and
but those are not determinative, and in fact they're not permitted to fetter the discretion of the individual decision maker in each case.
Yes, although not determinative, the Supreme Court of Baker said guidelines are useful indicators of what constitute reasonable interpretation of the powers conferred by the legislature. And again, in Agrera, the Supreme Court said that guidelines guide exercise of discretion and can assist the court in understanding the interpretation of, in that case, national interest, and in our case, unusual, undeserved, or disproportionate hardship.
Thank you.
And again, the court in McLean said that deference should be owed to administrative tribunals, which are intended by Parliament to be made interpreters of the administrative schemes they administer. So again, if assessing this on a correctness standard, we'd be pretty much depleting the purpose of having this immigration minister and the whole act from existing in the first place. Going back to the guidelines that, in our case, the minister relied on, which I see you don't have the factum, so I'll pass that along, please. This is at paragraph 67 of the factum, pages 22 to 23, citing section 5.11 of the IP5 manual, which was relied on the humanitarian compassion officer's decision. These include but aren't limited to ties to Canada, establishment in Canada, consequences of separation from relatives, best interests of the children affected, health considerations, and also include factors in the country of origin. And you'll see above that in paragraph 21, my friend referred to the Chu case, and those similar factors were assessed or were deemed relevant in assessing removal orders under humanitarian compassionate grounds. So we'll see consistency using these guidelines when applying or considering these factors and determining whether there is an exception relevant to state or not. So as my colleague will demonstrate, all these factors were assessed and addressed in the humanitarian compassion officer's decisions and reasons, and these reasons were justified, intelligible, and transparent. The decision fell within the range of possible acceptable outcomes in respect of the facts and laws described, and therefore the decision not to grant the appellate relief pursuant to the Act was reasonable.
Your Worships, so I'm going to focus on some of the facts and discuss why the ministry and the officer decided that it wouldn't be a case of unusual, undeserved, or disproportionate hardship. We do understand that Section 25 allows the ministry to act and to have an active role, and that was actually the case in the predecessor of this Immigration and Refugee Protection Act, Bill C-11, that they wanted the ministry to actually have a more active role in deciding cases, and the reason was that they wanted someone to actually assess all the factors and see if it is truly a harsh condition that the person would face if going back. Otherwise, if we were to, with the very little evidence, if we were to just let people stay in the country, then we might as well just not have that Section 25. So, factors that were assessed were psychological factors. Psychological factors in the documents that we received, we haven't received any documents showing that the appellant is actually being treated in Canada. So the question is now, one of the issues was that, one of the issues raised by my friends was that the appellant is suffering from psychological harm, and if it goes back, then might not be able to find proper medical treatment, whereas the appellant is actually not being treated in Canada either. And
so, was that noted in the original reasons? If I might just interrupt you. I presume reasons were provided by the immigration officer here in this case. They were written reasons. Is that correct?
There are in the factum, we do, yeah.
So written reasons were given at the time the decision or shortly thereafter was made with respect to denying humanitarian and compassionate grounds in this case. Did the reasons address all these points that you're raising? Were these in the original reasons, or are you kind of supplementing the reasons now, sort of before the court?
Basically, I'm going to go through three different things.
Okay.
One of them is the psychological factors. The other one is, I'm going to talk about the risk assessment, considering the time that the appellant entered into Canada and the time that we are basically dealing with this case. And last, I'm going to talk about the test as well, the rigidity, because my friends were arguing that the test might not be the right test in order to determine whether a person should be allowed to stay in this country or not, and I'm going to address that as well.
Sure. I just would like it to be clear sort of what was in the original reasons when you're talking about these reasons, and what you are just telling us now maybe for the first time with respect to this decision that was made.
With respect to the psychological test, basically there were no evidence brought to attention that the appellant was treated.
So it wasn't mentioned in the reasons at all?
No.
Okay.
And it's not in the record in the sense of something that was otherwise before the adjudicator. Original.
I'm not aware of it. So going back to the psychological reasons, the ministry have determined that there is adequate healthcare system in the country that will be able to look after the appellant. On top of that, one of the things that the ministry considered was that the risk toward this person was prosecuted or was detained twice in the past, but they allowed him, they basically let him go without any condition or any evidence pointing to a future problem for him. And one thing was that he left the country when he was 13, and right now that we are dealing with this case, he is 18 years old, and the ministry has serious doubt whether a 13-year-old would be of much significant importance to a group. With respect to the child's best interest, we believe that the ministry have assessed there is a proper education system. He can go back to the country and continue his education. He will be living with his first-class family, his parents and siblings. And considering all these factors, we believe that there is no unreasonable and harsh condition that he would face if he go back to Sri Lanka.
How old is he now, Council?
What's that?
How old is he now?
He's 18. So in 2010, he came to the country. He was 13, and 2015 he's 18, and that's. We actually thought that that was a big factor. I mean, if he was an older individual with more connections, political connections, or more factors, it would probably be a concern. But at that age, a 13-year-old left the country. Yeah.
But also, if he was younger than 18, it would also be a concern probably against his deportation as well. I can see it sort of cutting both ways. So maybe he's just in the sweet spot as far as you're concerned. Being 18, he's not a child any longer, so you can kind of send him back, basically, without too many ties.
My concern is that best interest of the child, one of our international obligations, benefit him when he originally came through this, and if this decision is found to be unreasonable and remitted to the Minister for reconsideration, then he no longer has the benefit of the best interests of the child, right? So he's sort of one strike down the ladder there. Do you have any thoughts on that?
Can you reword your question to be more specific?
Sounds pretty specific. Nice try. Reframe my question. If this is remitted as a consequence of being found unreasonable, the minister then makes the decision again. But the benefit that he would have had the first time of our treaty obligations with respect to children, he will no longer have because he's no longer a child. So, given that, if we were inclined to remit, wouldn't you think that remittance would work an injustice in this case?
I think it would just change one of the factors. I mean, we wouldn't probably consider the fact that him going back to his first-class family would be a big advantage, but still, the rest of the facts would stay the same, that he left the country before he was even a teen, and he didn't have strong ties and strong connections. It wouldn't change the fact that we don't think after 5 years of living in Canada and having no connection back home, he would be of any interest to anybody in his own country to take him back and prosecute him.
You have about 1 minute.
So considering all these factors, I don't think that there was exceptional, that he is not considered an exceptional applicant, and that's what we required under Section 25 in order to grant him to stay in the country.
Would the appellant wish to respond? I got 5 minutes.
We'd just like to respond on a few notes by our friend. First of all, the appellant was 16 at the time, was now 13, and he's 21 right now, so a 16-year-old would be of much more interest. And as you said, his age would hit him as a minor, which would engage our international obligations as well. That's part of our argument. Secondly, to the point that he was let go, he had to bribe the officials the second time to be released, and they told him to stay out of the capital city, and they told him that they would see him again if they had any suspicion that he was involved with the ELLA, as well as the fact that another militant group tried to recruit him. As to the point of the psychologist, he actually was diagnosed by a registered psychologist, and the fact that he was not actively seeking treatment at the time was not the issue. The issue is that the issue is not that he wasn't being treated in Canada, or he could not be treated in Sri Lanka. The issue is that by basically deporting him back to his country and exposing him to the risks there, it would make his PTSD much worse. And as to the other note of the intent, as to Section 25.1, the intent of Section 25.1 is to allow the minister to give discretion for those who wouldn't make it otherwise. So the fact that all of their means were exhausted is the exact reason 25.1 exists, is to have one more kind of escape route for people facing accentuating circumstances. And the actual statute itself just gives discretion, and it just states for humanitarian compassionate ground. The unusual and undeserved or disproportionate hardship test was adapted by a federal court, but it was never confirmed by Court of Appeal or the Supreme Court of Canada. Therefore, what we're asking for is a more broad interpretation of that legislation to fit more with the legislative intent, history, and Canada's obligations on the international community.
So I have a question. So if we took your approach and we mandated a broad interpretation of the legislation as you're advocating, we found the original decision to be unreasonable. What is the particular remedy that you're seeking in this case? Are you requesting us to quash the original order and send it back for a redetermination in accordance with this broader interpretation that you are arguing in favor of?
Absolutely. What we're not saying to change this ruling, but we're saying to send it back with a more broad interpretation of that statute, and then to have his application reapplied and go through the process again. We're not just simply asking for his individual case to be turned around.
Okay, thank you. Okay, well, there's no ruling because we're reserving judgment, I believe, but on this one, I have to say this is obviously a difficult area of the law, administrative law, and especially for those of you who have not yet taken administrative law. That is a difficult thing to wrap your head around. The law of judicial review is not easy, and the case law is all over the place, and it continues to evolve, so it's quite difficult. That is impressive in and of itself to be able to answer questions about administrative law in such a technical area. The first thing I would just suggest here to the appellant is when you're introducing the case, you gave a little overview of the facts, which is great. One thing that would have, I think, been a bit more helpful in this case, we didn't really hear it on either side, was what happened in the courts below. It's important that we hear not only what the immigration decision was, that it was refused, but also what happened on the first instance judicial review, what happened at the Court of Appeal in this case, and why. And maybe that can be quite brief, but it gives us, I think, sort of an outline of where this maybe is going. We have several judges that have already looked at this case and they decided this way or that way. And so I think that's quite important for us to know, and maybe some of the reasons for that as well. I thought the summary of the law was done very well. I think you were very clear in setting out a roadmap of where you were going and dividing the work, so the teamwork was very good. I'll be addressing point 1 and 2, and my co-counsel will be addressing point 3. I thought that was good. There was a little bit of reading at times, and that's okay, obviously. You're getting, it's difficult. This is obviously drafted by, the best lawyers in Canada for the Supreme Court of Canada, so, you want to make sure that you're getting everything right, so you're reading. But again, as we talked about some more other moots, it's important to know the facts cold and the law so that really you can engage. And especially when there's a question, I would say, it's important to take a moment, collect your thoughts, look up a little bit, and really make that eye contact and engage directly with the judge. You're not going to find the answer necessarily to your question and what you've written down. It's probably not the next point you have written down. So that's one thing I would say there as well. With respect to the respondents, I thought the discussion was good. One thing that I thought maybe could have been done a bit better was that the appellants had kind of laid out, here are the 3 things we're talking about. And it would have been really helpful for you to say, maybe, you did address them, but a little bit more sequentially and say, okay, in response to their point 1, they're advocating for correctness. Let's deal with that right now, and here's why it's wrong. Number 2, and you can sort of use their framework in a way as the skeleton, and you can sort of map your own arguments. You did address all their points, but it was kind of, sometimes it was here and there, and it was a bit all over the place. So that was one thing I would just say. Otherwise, I thought your presentation, your delivery was very good. You engaged with the judges well. I thought that was excellent. And lastly, I guess I would just say on the rebuttal, I thought that was effective. You just pointed out a few sort of facts that needed to be corrected for the record, and you were willing to engage on one other point as well. I know there's not a lot of time here, but addressing the remedy in a case like this is also very important, because no matter which way the court goes, if it adopts a reasonableness or a correctness standard, it wants to know how interventionist. The court really isn't able to make a full assessment of these types of cases, right? They're not on the ground, they don't have all the evidence. This is just in a courtroom that we're talking about this case. And so what it is exactly that you're claiming, and I really liked your approach to say, look, we're not asking for an order of mandamus to decide this case a certain way. It's very respectful, and we're just wanting it to go back down for reconsideration in accordance with what we think is the proper law, basically. So I thought that was well done. I think that's kind of it in terms of what I have to say. Justice Jones?
Well, I echo everything you said. I might expand on a few things. Generally, we don't have time to sort of go through individually points for style and whatnot, but really, really important how you enter into your respective sides of the case. You don't know how hot your bench is, how much we've read. I make a practice of reading nothing. And it's not just laziness, although that's certainly a big part of it. It's also because I want to see how quickly you can make me understand what this is about, and it falls upon you as the first speaker. And in this case, really, the invitation, it seems to me, would be to say, Mr. Kanthasamy, is that right, was, a boy in the northern Sri Lanka. He's a Tamil. He came south and got in trouble with the authorities. He was in prison twice. Just tell a little bit of that story. He came to Canada as a refugee at 16 years old and eventually applied for refugee status. This was the decision, as Professor Neudorf said, this was the decision of the adjudicator. And if you can introduce us to the issue at that point, that's great. The adjudicator took a very narrow reading of this exception, and this exception is what this case is all about. And then I go, oh, okay, this exception is what this case is all about. And then explain where judicial review went on the, did they just say that it was reasonable and didn't really confront the question of the interpretation of the statute? What happened then at the Court of Appeal, and how does it come before us? And then just say, these are the issues, 1, 2, 3, and go from there. So think about how you how you sequence everything, right? It's like you're entering a cathedral and you can just kind of jump around to this part and say, this is the parapet over here, and this is the back door, and that kind of stuff. Or you can say, we throw open doors and you take me by the hand and we walk through it, and you point to the things as we go along. And that's much more useful if you have a cold bench. Now, you may get 10 words into that story and have someone say, look, we've read the fact and we know the facts, get on with it. But if not, we're going to be troubled by what we don't understand about it, and we're going to miss some of the important things that you say because we're still going, how old is this guy? Right? So if you can lay that all out up front, that's very helpful. I thought everyone's discussion and familiarity with the law was good. Answering the questions was generally very well handled. You're learning, if you haven't already, you guys are all first year, right?
Well, 12.
Oh, sorry, 2 of them are first year and you guys are not. Okay. I don't even know who you are.
No one does.
The challenge is preparation, and this is a very artificial environment, right? You have 5 days, you have factums thrown at you, you have a very complicated case. So let me tell you about the way it should work normally, otherwise, if you're in a competitive mood or if you're in another situation. You've got, you're almost coming at it from the backwards point of view because you have the factum already, and that's going to naturally make you inclined to read your way in from the top down as opposed to, I don't even know if you read each other's factums here, right? That would be sort of basic if there were a longer prep time and you didn't have law school or something to attend to in the meantime. But think of what happens here, because everyone focuses on the day, right? How was my performance? How, did I speak too quickly? Did I speak too slowly? 90% of it at least is preparation. And it's like, going to a symphony or watching any sort of musical performance, play or anything like that. It only appears natural and fluid and flowing and whatnot because you've spent days and weeks and months slaving away, reading every case, learning all the facts. And so my feedback on how natural you looked or how fluid is really next to useless at this in this environment, except to say nobody fell on their butts. I thought you all spoke at a good pace. I thought that you all had decent eye contact, varying degrees of reading and familiarity. You did a great job when you came up because you recognized there was something that was still troubling us, and you went off script in order to address it, and you have to do that. And you tried to do a little bit of the same thing when you got up as respondent, and when you responded, that's your opportunity, because if there's been interactions and you think that the judges have maybe latched on to one of their points that you don't want them latched on to, clear that, and if you have a good answer for it, clear that away right away. Just say, you can do it a couple of ways. You can address it square on if it's a small point. You can say, I know you're troubled about the age. It turns out that he's 18 or whatever. But if it's a more complicated point, at the very least you can say, look, my friends made a lot out of this particular issue. I want you to know we're going to deal with that. We're going to deal with it squarely in the course of our submissions. But first I want to address the point of blah, 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 blah. And then the judge can at least clear that out of his mind temporarily and will be free to absorb what you're trying to say. Otherwise he's thinking, what about that all the time, and it's distracting. But you both took those opportunities, I think, to clear away some of the underbrush, and I thought it was effective. I liked the conversational style of most of it. Your intro was maybe a little more casual than I would have expected. I think, I can't remember what you said, this is about, or I don't remember what your first words were, but I found it slightly jarring. Samin, did you call us your worships?
Yes.
No, don't do that. Your worship is a mayor.
It's a mayor.
So you would say, my lords, this case. There's a sort of a bit of a hierarchy around it. Usually you'll have three, at least, judges on an appellate court. And so the senior judge is always the one that you address first. So if it's a woman with two men, you would say, my lady and my lords. If it's two women, one of whom is the senior, you would say, my ladies and my lord. If it's the men, if it's one of the men who's senior, you'd say, my lords, my lady. So you can learn those things as points for stop, but it's never your worship. And it's never your honor unless you're in provincial court. That's a big no-no as well. The Supreme Court of Canada just uses justice now. They prefer non-gender expression. So I guess those are my stylistic points, except for, as I say, endorsing everything that Professor Newdorf said. Any questions for us? Anything we can...
Do you have any questions?
On. I mean, really good job. And I just got a compliment. Sorry.
One question.
I'm just really impressed by this group and
I'm glad to hear
how seriously you take it.
Really well done.
And compliment all the males on the dress because that's my expertise. Just so well done. Yeah.
If I might, I'm sorry.
No, go ahead, please.
Okay. I noticed that at one point a personal experience was brought in, and I'm just wondering how appropriate is it to speak from personal experience, even if it's relevant to what you're talking about? Does the court care about that at all?
You would never, and people try to do it all the time. Like say, well, just last week I was, and then the other counsel will say, is my friend giving evidence now? So yeah, you want to avoid that. Having said that, it's one of those stupid things that the more senior you get, the more you seem to get away with that shit. Like some 70-year-old QC can stand up there and go, my granddaughter was telling me just the other week. And everyone just smiles and nods, and it can actually be a little bit effective from time to time. But as a young lawyer starting out, no, you do want to avoid any personal stuff. And maybe I'll make the same point with you guys that I make to pretty much everyone. You guys didn't do it very much, but when you say I submit, it is our position that these are words of weakness, and you want to make an exercise of just going through your written submissions and drawing a line through them and exorcising them from your oral submissions as much as possible. If that sentence won't stand without that disclaimer, then you should revisit that sentence. If you want to say Pushpanatan stands for this proposition, you don't need to say we submit that Pushpanatan stands for this proposition. And there's actually studies showing that weakens the power of your persuasiveness of your presentation.
If I might just quickly on your question, personal experiences, absolutely. But I think one area where you have a little bit more latitude is something that is a common experience to everyone. So for example, in a privacy case, you can say stuff like, we all put our trash out at the end of the street or something, because everyone knows what you're talking about. It's not a personal experience to you, but it is kind of a shared experience that everyone can say, okay, I can situate myself now in this privacy case and figure out what that means and what maybe the law should be. So that's...
A good rule of thumb is, if it's something that the judge would be entitled to take judicial notice of, if it's that level of common knowledge, then it's okay for you to talk about it. And then if your friend makes the obnoxious objection, you're giving evidence now, then you can say, I think it's open to the court to take judicial notice that Third meets Columbia right at the start of this, or whatever is the point you're trying to make. But yeah, good to raise that.